Welcome to Big Blend Radio with your hosts, Lisa and Nancy, editors of BigBlendMagazine.com.
Hey, everybody. Welcome to Big Blend Radio. You know, every fourth Wednesday, we like to hang out with Ward. Ward Heinrichs, to be exact. Ward is a San Diego employment attorney, and he is awesome because he comes on and teaches us all these words that we don't know anything about in regards to the law. But today he is joining us to really decipher legalese. This is part 2 of his legalese segments, but usually he's on the show giving us updates on what's going on in employment law in California and in San Diego. You can read his articles up on blendradioandtv.com. Also go to his website, bestemploymentattorneysandiego.com. So help, Ward, help. I say it's an objection.
Well, luckily I'm on the show today because I'll be able to explain to you exactly what an objection is.
Okay, because that is okay. So let's see. We've got 4 words because I know we were supposed to do 3, but I've already snuck a 4th one. We have appeal, perjury, hearsay, and objection. So does hearsay come before the objection?
Well, hearsay is an objection usually. Yeah. So you go objection, hearsay. All right. So here, I'll set the table.
Yeah.
You're in court and a witness is on the stand. Let's pretend that I am questioning the witness as an attorney. And I say, so, Mr. So-and-so, what did your friend say on Tuesday, November 5th? And he goes, he's about ready to tell us. And then the other side goes, objection, hearsay. And the reason why that is hearsay is he's going to tell you something that he heard outside of court. So a pretty good definition. Hearsay has different definitions, different states define it differently, but it all comes down to the same thing. I think maybe the best definition is it's an out-of-court statement made to prove the truth of the matter asserted.
Okay, but this is what I don't understand, because what if there's an incident, right? So let's go back to, there's the dude in November. Now let's do an employment law case, right? Discrimination, right? It's discrimination. So-and-so said something maybe racist to his employee. Okay, the dude did that, and then somebody heard that, because that would be hearsay because they heard it. I don't know. But here, I heard him say this, but it is outside the courtroom. Like, that's where I'm getting confused. So he could say, I heard my boss say the N-word to so-and-so who works with me, right?
Right.
And this happens all the time, by the way.
Yeah.
It does. And then that's why Ward is here. Call Ward if that happens to you. But because that's a no-no. And it's not just racist bad, but it's now like that's a no-no in a workplace situation, right? So if the other person was witness to that, would that be hearsay, or would that be like, okay, we're documenting this to build the case? What happens?
Well, hearsay has many exceptions. And now you got, all right, I'm going to set the table again a little bit. Back in England, when they were developing these rules of evidence.
With the wigs.
With the wigs and everything else.
Powder.
They decided that a statement that's made outside of court that someone later says, I heard this, is not really that reliable, because you could say you heard anything. You could say, hey, I heard so-and-so say this, and maybe it's true, maybe it's not. So they said, this is pretty unreliable, so we're going to exclude it. But then over time, they decide, well, there are times when the reliability is okay because of the circumstances. And one of them would be the one you, in the case that you brought up, would be a statement against a party's interest, or a statement that a party in the, a statement against interest, that could be anyone, doesn't have to be party. And then a statement that is made by a party that harms their interest. So in that case, looks like he's probably being sued, and he said something that was not proper, something that could violate the law and bring damages against him brought by someone else who was hurt by those statements. So those statements are allowed to be brought in because it hurts the party opponent in this case. But even if it wasn't, it probably still come in because it's against someone's interest. Usually that's like a criminal thing. You say, oh yeah, I robbed the bank and it has nothing to do with the case. I mean, that person's not being sued. He's not a party, but he just said it. Well, they may let it in because why would you say it if it weren't true? You don't want to admit that you.
Yeah.
So those are two exceptions that allow hearsay in, and there's a bunch more.
Is it still hearsay if there's someone else in the room that heard it? Doesn't that make it fact? Like if there's two people, one person says something, the other one heard it, or maybe there's two or three people, would they still call it hearsay?
Probably, because now, all right, if it's not a statement to which the party trying to elicit that statement in court is trying to prove the truth of that statement. So if it's like a car accident and someone said, I heard someone say the light was red. Now, that would be, they want to prove the truth of whether the light was red or not in that case, probably. So that would be hearsay. But if they were saying something like, oh, I live at 569, Main Street, and that is, then they're not trying to prove that he lives there. They're just trying to prove that he was in town. Yeah. Just generally, or could have been that, because he didn't even say that. I mean, he lives in this area. So if it's used for something like that, that might not be hearsay because you're not trying to prove those words exactly.
Wow. Because it's like when, the Amber Heard, and Johnny, they just, it's like they stop people, like the witness, from actually saying what they need to say. And the witness isn't always trained to say it the way the court wants it. They're just trying to tell the story. They come on there. This is why I thought the Johnny Depp and Amber Heard thing was really interesting, because here are all these famous people now involved, whether or not they really wanted to be. It's like, now you're a witness. And next thing you know, their laundry is out there now too. But as they start to try and tell something, I mean, the one, I think he was the security guy, or no, he worked at the condo place. He started driving and vaping. He was vaping and started driving during the deposition or the court case. People are sitting there watching him drive, and he's like, "This is some, it is hysterical." This was.
I didn't see that.
No, it's funny.
It is so, this court case, and now they're appealing, which I don't understand. So I'm glad you're still here on that.
Everybody's appealing everything.
Yeah, but they kept going. As the guy was trying to say something, they're like, that's hearsay, objection. And he's just like, dude, can I just say what I need to say so I can leave and go back to work? That's the kind of thing I'm trying to say. It's like they bring these witnesses in and they don't let the witness talk. I mean, I don't think I have the temperament to sit through being a witness without telling the person who keeps going objection, hearsay, to just shut up and let me say what I need to say so I can go.
Then you would be in contempt of court. You would.
Yeah, probably. I mean, if you said, if you got too obstreperous and the judge got tired of it, you could be in contempt.
Lord, that was a big word. That was a big word.
Well, thank you.
That was a big word. Well, for me. but yeah, I mean, it's
really interesting because the witness, I mean, they're just average people. They're not schooled in the law. And possibly, depending on who the lawyers are and what side you're on, you may be given some tips on how to act in court, but usually not. So you just go in and you're like, D, and then all these lawyers are firing questions and one's objection. You're like, what? What?
Well, all the witness has to do is wait for the objection and then hear the objection, then wait for the judge to make a ruling. That's usually what you tell your witnesses. Well, if there's an objection, just wait. And you'll hear, and a lot of these things are really thought of beforehand. So if there's, you're pretty sure, well, I might get an objection if I ask the question this way. Maybe I should ask it a different way. That's one way you can handle it. Another way is, well, it looks like there's an exception to this hearsay. So if they do object, I'll say, well, it's a statement against a party opponent. So, and then the judge, if I'm right, then the judge say, yep, overruled. It's allowable. That's an exception to hearsay. But so you usually try to think of these things in advance. But if you don't, it can be trying for the witness, but the witness, you really just have to be patient. That's the main thing.
The hearsay thing sounds like
Don't
gossip.
call me.
It sounds like, no, that's just gossip. When you say hearsay, it sounds to me
that's
like
what
it's
I thought.
Gossip.
When I was watching that,
like it's not factual. Oh,
no, and that goes to your.
You said it.
It goes to your point a little bit where you said, well, if 2 or 3 people hear it, is it okay? And I went into, well, maybe it's not hearsay, so it would be okay under that circumstance. But if it's still hearsay and you can't find an exception, doesn't matter how many people heard it.
Oh, wow.
So, wait a minute. So when Amber Heard said about Johnny Depp that she punched him in the face, right? And she admitted she did this, but she did it out of self-defense because she goes, because of the Kate Moss thing, that he allegedly pushed Kate Moss down the stairs years ago when he dated her. This is so this is all hearsay because I'm recounting it and I am not always correct. So allegedly, everything's alleged.
If you were in court, yes, when you say she said X, that would be hearsay.
So she did this, and the lawyer and Johnny Depp are like, dude, like fist bump, yes, when she brought up Kate Moss, because she wasn't there when Kate Moss did fall down a flight of stairs. So they both looked at each other like, oh, well, then she's just opened up Pandora's box. So next, Kate Moss goes on stand to tell everybody, yes, I fell down the stairs. It's called a storm and there was a bunch of water and I slipped and Johnny came running back, picked me up, got me medical attention. And apparently she just now did an interview again. Like she's rare. I mean, we never hear about Kate Moss anymore. She was like, one of the most beautiful women in the world, comes on finally going, yeah, like I did not want him to have this thing against him when he never did it.
Yeah.
So Amber Heard, by her saying this statement about Kate Moss, that is one of those things that really actually nailed her coffin in the trial, I think.
Well, and that's interesting because since she didn't witness it, now you can say anything you witness, you can tell about. So if you saw it, heard it, felt it, smelled it, you can explain that in court. There's no objection for most of that kind of thing, unless there's another basis. But because she wasn't there, she probably heard it through some other source, and that would be hearsay. It doesn't matter whether it's someone telling you or you read it. That would still be an out-of-court statement. The piece of paper that you read it on or the computer you read it on would be considered to be like another person telling you.
Right.
So that would be hearsay as well.
It's gossip.
But she said that's why she hit him out of defense, because she thought she was going to end up, or her sister or something, one of them was going to end up hit at the stairs. And
dude, I think you have to wait for somebody to kind of swing at you before you swing at them.
Yeah.
You know what I mean? Like, well,
well, I don't know. Like, we weren't there.
But I mean,
it seems like good advice.
I mean,
it's kind of like before you slug the other person thinking they're going to slug you. I don't know.
Because like you can't say like, okay, so when she pooed on the bed, we don't know that did she really poo on the bed? Like no one, but if they saw the poo, we don't know. I'm sorry, but I'll still to this day. She admitted that she did poo on the bed, so eventually hearsay became reality. But
it depends, and there may be reasons why you let hearsay in, because like in this case, I think Amber Heard probably didn't witness the stair falling incident, probably learned it outside of court, probably hearsay. But Johnny Depp's going, cool. We're not even going to object because we'll bring my old girlfriend in, and she'll tell the truth.
Yeah, exactly. And but see, this was Amber Heard. It could be allowed also because it was her mentality of when she hit him, that because of that story, she thought he was going to do it to her. So that was like a mentality thing. See
Okay,
what I
well,
mean?
that's interesting too, because there's something called state of mind, which is another exception to the hearsay rule. If you're not, again, you're not trying to prove the truth of the statement, you're just trying to show what what's in their mind at the time.
Right.
Yeah.
And the reason why I'm thinking this, Judge, is I heard about this. Well,
Yeah.
that probably comes in
That
not to
could-
prove the truth, but to show how she is thinking about her encounter with John.
Yeah, like, okay, because if I read or heard that this guy had smacked a other lady around and pushed downstairs, and now he's coming at me, or I feel like he is, then I'm going to be on extra alert. And if I can hit him first, I might.
Yeah, I could see that coming in for
Watch
that
out
reason.
for Nancy.
State of mind. Nancy's got a
Well-
state of mind. She read the Johnny Depp transcripts and she's
It's the
thinking
hot-
she's going to get
Hot
hit.
Mama
Yeah.
Babushka. She knows what's coming.
No, it's like
We'll
if
get
you
her on
think
the
you're
show
going to
again.
get hit and you've heard tales before, whether you believe them or not, suddenly they click through if he's
Yeah.
threatening. But I think it's really interesting that they're both actors. So who knows? It's like
Yeah.
who's out acting who?
It's weird. So
Like,
she
are they
goes,
being real people, or are they like suddenly he becomes Jack Sparrow? And I
Yeah.
don't know who she's Aquaman, or I don't know what she did in
Aquawoman.
Aquaman. I've never seen her in anything, so I don't know.
I don't know.
But she
But-
acted
but-
in Aquaman. I don't know if she was a fish or a dolphin or a. I don't
My
know.
God, Nancy, we're gonna
No,
see
I'm
Wart's
so gonna
keeping
get
quiet.
involved.
He's like, I'm
No,
not gonna get involved.
I
I'm
know,
not gonna
but
go
I mean,
down
I
this
don't know.
road.
I
I'm
don't
not
know
doing
what
it.
she was in Aquaman. Like she could have been a
A bed pooper.
sea urchin. I don't know.
A pet pooper. Yes, she could have been. But if you
Sorry,
didn't
I
see
can't
it,
help it.
then it's hearsay.
Yeah, I know.
That's right.
Okay, but let me, okay. So there's the hearsay, the objection. So this is like when you watched it, that's all you heard. So all these YouTubers are going in and
Yeah.
I mean, this court case was insane. And then just, it's kind of what's going on with the trials over January 6th. Like you could sit there and watch it all day,
Oh,
or you wait for someone to distill it and edit it down for you. And I think this is very interesting, these hearings, because it's like court.
I think it's a
kind
little
of
more
crazy.
important than Johnny Depp.
Well,
and
yes,
Amber
yes,
Heard.
but so I'm using the entertainment side, but
Yeah.
it's also this case with Amber Heard and Johnny Depp isn't going away, and it is
Mm-mm.
a case on abuse, which is, we're laughing, but it's not funny
But we don't
because
know.
someone got abused somewhere, somehow. And as if if he didn't do anything at all, it's a really crappy thing for women who have been abused and vice versa kind of thing. It's a
Yeah.
weird thing. And now it seems like they're bullying each other. She wants to appeal and he's starting to appeal. So is this like another court case that could happen just because they want to play I appeal? What's with that? Like,
I mean, how many times
isn't
can
it
you
once the
appeal?
court says and the jury says, screw it, that's done, isn't it done? You won the case, but now we're playing appeal.
Yeah, generally, it's not completely done if the parties want to appeal. And in my experience, most parties don't appeal. It takes a lot of money usually. So it's, you got to get over the hurdle of finances. But assuming that you can, assuming that you think you have an issue that you want to fight, then yes, you have the right to appeal a verdict or a finding in at least California Superior Court or the same type of court throughout the country. There are appellate courts to hear those types of things. Now, there are different kinds of appeals, though, too. Sometimes you have appeals from an agency hearing. So, for instance, the labor commissioner does DLSE hearings, Department of Labor Standards Enforcement, and that's a department underneath the labor commissioner, and they do hearings on wage and hour issues. That's mainly what they do. So you do have the right to appeal, but you can only appeal it to a judge in Superior Court. And then there may be a writ possible after that. So the Supreme Court would never hear anything like this, at least usually. So there are different kinds of appeals. Like for agencies, yeah, you might get a chance to put it in front of a judge. But in this case, I was just telling you about, the labor commissioner hearings where they're doing wage types of issues, you have the losing, well, if the employer lost, they have to write a check and deposit it in the court for the amount of the award. So again, there's always a cost.
But this is what they
Whoa.
did to Amber Heard. Like
Wow.
they said that the judge turned around and says, well, you need to pay your bills before you appeal. Like she needs to pay the
Oh, 'cause
court
she
what she
hasn't-
lost or something. Yeah.
Yeah, and I'd have to know more specifics about that to know why the
I
judge would say
can't
that.
help
But
you. I'm not good
yeah,
at
there's
it.
certainly
Yeah.
times when you have to post some type of bond or post
Yeah.
a check with the court before you can appeal. There are
Yeah.
different rules. I know if you're out of state and you want to appeal a hearing that or a verdict that happened in California, you can be made to post a bond for that.
That was, they did it in Virginia, which I thought was interesting. Most of their time was in California. I believe Australia is going after her for smuggling her dogs out of the country
Yeah.
or into the country, excuse me.
Oh,
There's like all this drama. Yeah, there's all kinds of
In or out?
smuggling in, because they said that they have to have
Mhm.
papers and all that stuff. But
Oh,
anyhow,
yeah.
but
That's
so
dumb.
their court case was in Alexandria, Virginia, and I'm like, aren't they mostly in La La Land and Hollywood and all of
And
that?
that may be
Why?
why she had to post money before she could take the appeal, because they were out
And
of
she
state.
doesn't have very much apparently.
And that can
And
be
now he's
prohibitive.
like, it's, we say in South Africa, he's doddering her now. Like, you want to play this game? Let's go, let's go, let's go. He's got more money than she does. But so when someone appeals, there's the money thing. How does it end up being out of state? Like, I mean, for you, I know you represent California. Your clients are Californian, and then sometimes there's laws that are San Diego, just specific the city versus, county
County.
versus state.
Mhm.
When does I mean, what happens, like when we were talking about Uber and all of those things, like a class action suit happens, what happens if it's like a giant company like Amazon or something that has, offices all over the country and something goes down in California? Does it have to be tried in California if there's a court case? Or can it be somewhere else?
Well, if the wrong happened in California, yeah. And then the question there would be, well, does it have to be heard by the Superior Court, or can it be heard by a federal court? Well, since you have an out-of-state party, they can say, hey, we want it heard in federal court. And many companies would prefer to be in federal court than state court. So that's fairly common.
Oh, really?
Well,
Yeah,
because you get it done all at once.
Oh, I
Finish it.
see.
Well-
Instead of going state by state by state. I mean, if you're Amazon and you're in every state, everybody could just get on the bandwagon and go state by state by state.
Well, actually, they can, and it doesn't mean that all those cases would end up being melded together.
Yeah,
Oh.
they'd
But
be separate.
all right, so if we're talking about class action, for instance,
Hmm.
you can have a nationwide class act,
Hmm.
and normally that's going to have to be in federal court somewhere.
Hmm.
But if the same wrong happened in all 50 states, each state could be the forum for a class action. So you might have potentially 50 separate state
Yikes.
class actions. Now, I did say if the company has its headquarters, I mean, there's other rules on this, but to keep it simple, headquarters in a different state, then they can say, well, we want to be in federal court. They can usually say that. And in class actions, there's a whole bunch of different rules on it that are pretty complicated, and I don't want to get into all those details.
Hmm.
Probably be able to get it into federal court if they want to. But again, still going to be in that state if it's a state class action where the wrong happened. It's possible that there's one wrong that covers people from all over the country, and you can one court. That is possible too.
So what happens for you as an attorney with, like, say it was Amazon did something bad and you're representing, say, the employees? If they say, hey, we're going federal, do they send you to wherever they want to go federally? I mean, do they hook you up with sweet lodgings and pizza?
No. The
I'm
real
like, they
question.
gotta pay Ward's way. Send him to Hawaii.
Yeah, well, right. That'd be great. I'd live in Hawaii for a year. Fantastic. But usually it would end up being in the federal court where the state action was brought. normally the wrongs you're trying to sue for in a case like that would be in California. So you're going to have at least the forum of California, whether it's in federal or state court. It's also, I don't want to make it too simple either on the other hand, because it's possible that you could get transferred to a different court. Depends on a bunch of different things. And so it's possible that you might have to go, oh yeah, no, this should be heard for economic reasons and for judicial economy in Kansas City Federal Court.
Barbecue.
So that's what we're gonna have. So again, it depends on how the cases are set up more than anything.
So would you go to Kansas City if they did that? They would you would now have to go to Kansas City suddenly for the case.
Well,
and eat
all right.
barbecue.
So then there's special rules for that. It's called pro hoc vice. And then you normally, because unless you have a license to practice in a state, you can't. Now, some instances there's what we call reciprocity. So if you're in Missouri, you can probably get reciprocity with Kansas and get over the border and try a case there. I would guess. I may be totally wrong on that. California doesn't give reciprocity to anyone, or at least they used to not. And I'm pretty sure they still don't. So you have to do so the other states don't do it for us. So if I have to go to Kansas City to try a case, what I normally would have to do is use the pro hoc vice mechanism. And that is where there's a whole list of things you got to do, and each state's just slightly different. You usually have to get in contact with an attorney out there, and they have to say, yes, we'll help this guy do his case here. He can come in pro hoc vice. And so,
dude, talk about some legalese. What the hell, dude? That's like two big words going on.
How are you going to know? No, because how are you going to
hearsay.
know if you're in California and you know California law? That's big enough. But now you go to Kansas. Now you're suddenly supposed to know the ins and outs of every law in Kansas. No. So you have to have somebody.
Yeah, that can be really complicated too, because just because you're in a different state doesn't mean you're going to use the rules of that state, the law of that state. Contracts often say, no matter where this is, you're going to use the rule, the law of California. Some contracts say you can only be in California and use the rules of California. Some contracts say you can be in California, but you got to use the rules of Missouri. Usually that's a contractual thing, but it's
But if you get sent to Kansas City, Missouri, you're eating barbecue, right? You are going to have barbecue.
Yes, barbecue for sure. I will come back 30 pounds heavier than I left. But
you'd be happy.
But then
I'd be very happy.
When somebody's signing this contract, do they even know that they're signing that?
Well, I had a case not too long ago where,
because
and then it got shipped off to Utah, and it's a big old problem.
Yeah.
I can't get into all the details.
But there's no
you
barbecue.
Said Utah.
It's not.
That's
there's no barbecue. There's no cocktails. That depends on where you go. If you go to Park City, now they have distilleries downtown in Park City. Now, if they have the case in Park City, you should go.
Or get married several times in Utah.
Now we're all going to get in trouble, Ward. That's it. Hey, that happened in Arizona too, man. Apparently they spread out. But
no, it's illegal in Utah. I shouldn't say that.
Okay, but now you've got us in thick with all these different words that we didn't know about, which I think that's what's so cool about this, because I never, always what happens with the attorney? Like things happen on TV shows. And so perjury.
Well, let me tell you something. Okay. Let me tell you something about appeal real quick, just kind of wrap it all up. You got to remember, on appeal, it's not like a whole new case. Whatever the record was in the trial court goes up to the appellate court, and they decide whether the trial court got it right based on the record that was made in the trial court. So normally you don't get to put new facts in. It's the same case. It's just new eyes looking at the facts.
But you don't go to court and testify again, or you do?
No, not on an appeal. It's the court, because you usually have a court reporter or maybe a tape recording, however you want to do it. and then someone makes an official record of that proceeding, and that record goes up. And then if you introduced evidence, documents and things, that would go up too.
Okay, but isn't this weird then? Like, okay, so when there's let's go back to the jury, because part of that was she wanted the appeal because the jury member, and then it turned out to be stupid. She was like, one jury member knew or didn't, I don't know, whatever it was.
It was something about his his age.
No, he took his dad's place, I think it was. His dad got a summons to be a juror, and he went in for his dad. Now, I never heard why he did that, whether he's just helping his dad out or he wanted to get in on this case. But yeah, so basically he lied. He wasn't supposed to be there.
Oh, okay.
Yeah,
so then she's got a point then.
That's different than what I read. I read that they just transposed the numbers on the driver's license or something, so he was the wrong age.
Yeah,
I didn't hear that.
Oh, no, but you know what? Nancy reads all the gossip papers. So
I do. I go in there and I was like, okay, let me go see. And I read, but I didn't. Wow.
Well,
maybe.
I heard that, he just, I don't know why.
This is
maybe
all
you're right.
hearsay.
Maybe it was transposed, but they thought it was a different guy.
This is all hearsay. I'm just saying.
Yeah, it's hearsay.
Yeah, this is here. Well,
this is hearsay.
If you were
Allegedly.
a judge, this would be hearsay. Yes.
Okay, so here's the thing. So you've got your jury coming in, and we need to talk about juries being picked, because I thought people isn't there something where the attorneys can kind of say, yes, we agree to this jury member or whatever. Yeah. And then, so, I mean, they all saw it. So if you're going to now go, yeah, about the jury person, didn't your attorney already say yes? Right? I mean.
Well, let's use another term. It's called voir dire.
Oh my God. Is that, wait, is that what you're named after? Voir dire?
No, it's not war dire. It's voir dire with a V.
That's different.
War. And it's actually French. And I think it means speaks, listen, something like that. I'd have to look it up. But it's really where you get to quiz the jury about their background in relation to the case, some relevant things. And so that's when and most times attorneys call it picking a jury.
Yeah.
But the official term is voir dire.
Oh my gosh, Ward, how did you do this?
It sounds like a new drink.
I know, I don't know how you guys go through this, guys and gals, ladies, going through the whole legalese thing. I would fail just on the legalese.
No, but
seriously.
But picking the jury, they both attorneys have to agree that every jury member is okay.
Okay, but what happens if you say
not true.
No,
False.
not true.
False. So this is the legalese that's going out the window. From now on, it is
okay. So
you're right or wrong.
So they don't agree on the jury?
No, you get to challenge jurors. There's challenge for cause where you go, oh, this person's obviously so prejudiced about the issues in this case or the case in general, they can't sit. So that's called for cause. The other one is peremptory challenge, which is another good word, peremptory. That means those are challenges that you can just exercise on anyone for any reason. You don't have to have a reason.
Oh, well, that sucks.
You get it depends on what court and what state and other things, but you probably get between 6 and 12 challenges to the jurors. A peremptory challenge where you can just say, this person has to go.
I don't like her hair
normally
color.
You go, I thank and excuse juror number 8, John Washington, for being here. Thank you for coming.
Well, it's like,
Thank you for playing.
Think you're too old, get out.
Nice, Nancy. That's called discrimination.
No, but I mean, can you say, I think that depending on the case you're trying, if you feel like older people wouldn't understand the younger thing that's happening in the case, then you can say, I'm sorry.
See, she's going back to politics.
Yeah, no, you really can't. The Supreme Court came out with a decision, the United States Supreme Court came out with a decision that said the jury has a vested interest, and I don't remember the exact terms they use, but it's something like this, has an interest in being free from discrimination. So it was a right that the jury had for the first time that I know of that they ever said anything.
Wow.
So you can't discriminate against the jury. And I don't know how broad it's gotten, whether it's gotten past sex and race and into age, but I'll bet you it has. And so if you said, you're too old, goodbye for cause, the judge would go, no. And if you said, well, you're old, Mrs. Snowden, you're just too old, I'm going to use
Snowden. I like that.
The judge would probably, the other side would object, and they'd say, hey,
and
that's
Snowden's
not a proper.
Going to come after you, man.
Maybe.
But I mean,
if she can hear me. I don't know if she can. But see, that's the point. What you can do rather than go after someone's age is test their ability to hear, perceive. Okay. So, and if they can't hear or perceive, then they could be excused, probably for cause.
Yeah.
Wow. Okay. So this is really, when you think about court cases and law,
it's interesting.
Because of the legalese, like to me, it's like, wow, you got some fancy words, but it does actually kind of sound like
makes sense.
A game. Like, here's your rules. And it's kind of like chess, like you're playing. It's like, ooh, I've got this card over here. Don't use it now. Wait for later, right? So
it would be a great board game.
Yeah, I know.
A great board game.
Going to court. Legalese game. You've got to have when you're making a board game, Ward, I think you should.
Well, when I was a kid, they had a board game. I forget what they called it, but you kind of read out this fact scenario, and then you asked everyone. It had to do with court. It was a court thing,
cool.
Like
really?
Perry Mason, lawyer in the court. I don't remember exactly.
Nancy.
And then you got to vote on how you thought the jury would come out on it.
Oh, cool.
And so I remember doing that when I was a kid. And I think something like that might be fun, especially if you started acting it out. If you could get in, you start taking on the character of certain players in a scenario. I think that might be pretty interesting.
And your little pieces that go around the board, there's that little Scotty dog like in Monopoly and the little car.
Sure. Whatever.
If it's a Scotty dog, the Scotty dog is going to go pee on the fire hydrant.
No, but he's going to be a detective.
Whatever token you want, Nancy, you can have.
That's it. Hot Mama Babushka token. Okay.
I want the Scotty dog.
But doesn't those kind of games also help, like when we had debate teams and stuff, isn't that kind of go towards being a lawyer doing debate?
Oh yeah, because argument is well, if you go to court anyway, well, even if you don't, argument is a basic tool of a lawyer, almost in any type of situation.
So you're a professional arguer.
Well, I mean, all right. So I do litigation or pre-litigation stuff mostly. And so I'm writing letters that say, hey, you did this wrong, or my client didn't do this, whatever it is. And so you do amass facts that support your position. And then you say, this is why I think that way. So especially someone who does the kind of work I do. Yes. Argument is a tool that you use.
Yeah,
okay, so
I would say someone all right. So if you're doing Preston wills, I don't think argument's a big part of it, because you're just trying to get this person a legal document that's protecting this person
right
to pass away in their errors. But if things go wrong, you're going to be in court arguing about it.
Argument, because they're going he's not related. And then you're like, no, he is related.
But everybody doesn't want it to go to that extreme, because then it costs everybody more money. And trauma. It can be traumatic for people. Like court cases are not like, you don't do it just for the fun of it.
Most people want to settle, and I understand why, because it's a lot of work for both sides. And depending on the case, I can't do all cases on contingency. So I'm certainly say, hey, you have to pay me.
Yeah.
And that can be very costly. So it's work and it's costly often.
Yeah.
It's a lot of time and work and investigation and going down rabbit hole after rabbit hole. It's kind of cool.
Okay,
I like it when I work for insurance companies and they like, okay, go, walk this intersection, photograph it. I got way down the rabbit hole with it because I'm like, dude, there's skid marks over here. Is that, let's go look at the tire tread. Does that match that tire? It was cool.
See, but I'm into that too.
Yeah.
I think it's cool.
That's more of what police do in reference to criminal cases. They gather the evidence, and that's what you're doing, gathering evidence. And then that evidence is what the attorneys will use.
Yeah.
Okay. So the evidence thing, that's interesting because when you think about, like we were talking about hearsay, like evidence is important. Your witnesses are part of the evidence team, basically,
Yes.
right?
Mhm.
Yeah.
And what if, like, okay, so someone says, okay, I'll go be a witness for this. I saw this happen. And then they get in there and they flip on you. Can that happen? Has a witness like turned around and done the complete opposite than what you think? Like, not necessarily to you personally, like, in your person,
Yeah.
but has that ever happened? Like where a witness goes in, yeah, I'll be on their side, and then turn around and be like the other way, like just
Well,
total, like,
I'm sure it has.
a
And
traitor, be a
I,
traitor.
yeah, I have to say, most attorneys who litigate really try to avoid that.
Yeah.
So you really try to figure out where a person's coming from, and you try to, maybe you have someone listen to their witness statement so they could testify if that person says something else. If they're really friendly to your client, then you probably don't have to worry about it quite so much. So it depends on the situation, at least to some degree. I would say this: I don't think anyone's ever done a 180 on me before, but I've had people not testify as accurately and as helpfully to my client. They weren't as accurate as I thought they were going to be, and they weren't as helpful to my client. So
Yeah,
I've had
Because people get jittery. I mean,
yeah,
I used to set up these cases for the auto club, car accidents, and it was really interesting to me how I'd have a statement that somebody else took from the person involved in the accident, and they basically couldn't remember anything. Then I would go talk to them, and suddenly, they remembered this, that, and the other. And then you formulate the case and you go after the person for money based on these statements. And if it went to court, then suddenly they went back to, I don't remember.
that can happen. Now, there's ways, at least in civil court, when you're doing a lawsuit, that you try to lock people in, and that's with a deposition. So if you take a deposition and they say, well, here's what I saw, and then they get into court and say the opposite, you can say, well, on your deposition, do you remember taking a deposition? Yeah. Did you sign it under penalty of perjury? Yeah. Did you, do you remember what you said? Well, no. Well, let's take a look at page 150, line 3. Can you read that to the jury? And you're probably showing it to the jury. And I can just read it out. If it's against the party, I can just read it out and go, on this date, you said this. Do you want to change your testimony now?
You go, Ward.
I love it.
You use the P word, perjury, which was one of the words we wanted to talk about today.
Right.
And I realized perjury, and then there's contempt of court, which I don't know why I got that twirled around in my head earlier, but perjury.
Steve Bannon.
So because of Steve Bannon, getting in trouble. And so the contempt of court, you always see lawyers end up in jail because they went far, and the judge said, if you don't shut up one more time, I'm going to put you in contempt of court. Boom, and they're in jail for 24 hours or something. I don't know, whatever it is. TV shows
I
are
do
all
have a
right.
good story about that, but
Go
this
ahead.
is not the time. I'm not going to get into it.
Okay.
Dude, I want to know.
I'm going to remember now. Next time, Legalese Part 3, we're going in for the story. But perjury, contempt of court. I mean, it's like, is contempt of court when you just basically don't listen to what the judge says?
It's when you lie.
Well, that's when you're violating court rules, and the court says, look, you as a witness, you can't just say whatever you want. You can't grandstand. You can't jump up, go crazy. So I've warned you 3 times now, and now I'm holding you in contempt. And and contempt can be, there's different penalties for contempt. You don't have to throw someone in jail, but you can. You can issue fines, do other things.
It's disrespect for the law.
The court. So, like, if you were the attorney,
in the courtroom,
if you were the attorney in England and you didn't wear your wig for 3 days, the judge could go, that's it, you're out.
Do they have to wear?
Yes. All right. So I'm going to tell you my story since we're on contempt of court.
Okay.
So it was a criminal case, and I was representing this guy who was charged with some type of financial fraud. And I don't remember the exact charges. And they had caught him admitting to it in a civil case
Ooh.
under oath in a deposition. So
Oh.
the judge says, all right, we're here. We I hear you want to plead out, and, we can get you a kind of good deal, but you got to admit certain things. And the guy goes, no, I'm not bringing anything in. I'm not showing you anything. I'm not going to cooperate. And he did this for like 20 minutes. And finally the judge says, well, I guess you'll go into jail now. And so the bailiff grabs him, puts handcuffs on him, and sits him down and takes him in the back, because now he could be transported to the county lockup, the jail. And I go, hey, Judge, can I just have a minute with my client? I'll bet you we can get you what you want now. And he goes, well, I'll give you 5 minutes. And so I talked to him and say, hey, you can go to jail right now if you want, or you can just cooperate, and then you won't go to jail. And so that's what he did. And so it ended up okay, but the judge really did cart him off. Absolutely.
Yeah.
Wow.
Oh,
Wow. So,
cool.
so it's basically
That's
respect.
cool.
And then perjury, is that when you lied
Yeah.
as a witness? Perjury is lying.
It's lying under oath.
Yeah.
And you not only do you see it in court where you take an oath, and so you're supposed to tell the truth. And if you don't tell the truth willfully, it's usually, different states may define it slightly differently, but it's usually you purposefully did not tell the truth under oath.
Yeah.
And so if you're caught doing that, you can be charged with a crime. Realistically, people don't tell the truth all the time in court, and not very often are you prosecuted for it. Every once in a while, I've never seen someone be prosecuted in any case I've done.
Really?
But probably maybe the trickier place is where you sign a government form under penalty of perjury. Maybe the DMV. Many of those agencies have different
Those
penalty
little fine print
forms.
things that none of us actually read.
You may not even read it, but often it's under penalty of perjury. It kind of depends on what the purpose is. And if they go, oh, you lied about something that's important to this agency under oath, you could be charged with penalty of perjury. And I think that's more common, actually, is the written. Because, to tell someone's really lying purposefully in court, it's kind of hard.
It's
but
very
if they do something under oath, and they go, hey, is this true? Now, unless it's a mistake, could be a mistake, but it's a little easier to show on paper that it probably wasn't really a mistake.
I'm just thinking back to the days with the car accidents and stuff. Some of the court cases took over 2 years before they actually went to court. And so you'd be talking to some lady who remembered everything when you took the witness statement. But then when it went to court, she'd be all like, I really don't really quite remember anymore. And so your whole case would go down the tubes because she's 2 years older. Or somebody told her, advice-wise, don't get that involved, just don't remember, and you don't have to feel guilty about anything, or you won't be the deciding. That's what I used to hear. You don't want to be the deciding factor in the case.
That means you're playing God.
So you know what I'm talking about? The deciding factor in the case? Like if there's more than one witness and 3 people saw somebody run a red light, you're fine. But if you're the only one, you are the deciding factor, and therefore you are responsible for the verdict in the case. And people don't want that. That's what I learned from the Automobile Club.
I would assume that some people feel that way. I mean, if I felt like I perceived something clearly, I don't think I'd be afraid to just state it. But I guess, you have to be in the situation. And maybe you feel like you didn't see it clearly. Go, well, this is what I thought, but boy, am I sure I'm right?
You know what? And that's the thing. We just watched the documentary of the series on DB Cooper, who jumped a plane with all the money.
Right.
And it's really cool. But it's like they're going, like, the longer the case goes, the more people have different stories and how they remember things differently and all of that. So I think that's what's always a challenge for these big cases, that especially during COVID, how cases got dragged out over time. Everybody's statements had to have changed, or their memories got to change. And so it's just such it's
true,
complex
because
what you do.
Your memory is your memory on the spot. this just happened. I saw this. That's what I saw. That's when, now 2 days later, your brain kicks in and starts saying, is that logical?
But
Does
that's
it
what I
make
like about the
sense?
appeal,
And
what
then
you
you
said
start,
about the appeal, that it's not going
Yeah.
back to jury, and because now everybody knows about the case. So like Johnny Depp and Amber Heard, they're going to appeal it. Even the people that are the muckety mucks at the
oh, but
top,
they're just appealing it over the money.
but it's going to be, they've already
I mean,
heard the
it's
case to
stupid.
death.
Yeah,
So
the
that's
record that was
different.
made in the trial court is the one that's going to go up on appeal.
Exactly.
So you won't have people retestifying.
Yeah, exactly.
It's
So I
just,
think
it's
that's a good
about
thing.
the amount
Yeah.
of money more
Wow.
than anything. Because I mean, they both were stupid
Well,
to each
we
other.
don't know. Allegedly. Allegedly. Look at
whatever.
Ward. He just goes,
But-
whenever it's anything about like the alleged,
But-
he's just
Yeah,
not
I-
saying anything.
I don't know
just-
enough about it. I know
Yeah.
that he got a pretty good verdict, and I did see
Mhm.
some of his testimony and some of hers, and I have to say, he looked decently believable to me, and I
Yeah.
thought she looked
And
a
she
little less
didn't.
believable. But boy, does that mean she's lying?
Who knows? I
don't
know
know,
that's
because-
what
no,
happens if she turns out
she-
to be right
No,
after
she
years
just,
later, you know?
you know, the thing is, he appeared to not be acting. She appeared to be acting. Like
Or
she
maybe
was,
he's such a good actor he can appear not to be acting.
exactly
what Nancy
That's it.
says.
He's way better than her.
And
She
has
was
more
kinda-
money to do things, you know?
No,
So
she
there it
came
is.
off like Greta Garbo. Like,
Oh,
"Oh,
she-
I want to be alone." She was more like that. She was too dramatic, so it's not believable.
I
Sorry,
thought she was a little dramatic. That's-
Yeah,
Yeah.
yeah. So she
Oh.
wasn't believable. So she's not only did she lose, she's not a good actress.
So Ward,
Oopsie.
next time you come on the show, I know we have other employment law issues happening that we'll be covering, but I say that next time you come on the show, we'll talk about how to be a good witness, how to be believable in your case.
Oh, that's good. I like that.
We can talk
Ooh.
about that. I mean, basically, the truth usually comes across pretty well,
Yeah.
but there are times when, you know, nerves or something else might even distort that.
Yeah. Oh my
Yeah.
God, that's a whole other side of law that we haven't discussed. It's cool. Well, thank you for giving us our legalese lesson today, part 2.
Oh,
Everyone,
you're welcome.
part 1 is up on blendradio and tv.com, also on our YouTube channel. Keep up with Ward. Go to bestemploymentattorneysandiego.com. Ooh, I almost screwed it up after all these years.
Dude,
Did you hear that?
you
I almost had to think.
It was
Is
just hearsay, though.
Don't, no,
Yes, hearsay.
no, it's not. Ward's a badass lawyer. Go to bestemploymentattorneysandiego.com.
That's it. You should just get badass lawyer
Yeah.
San Diego.
Yeah, that's
.com.
it. That's it.
Badass.
And everybody, if you don't know what that
Badass
means,
attorney.
I can't help you.
If I can't help you, no one can help you.
Yeah, I know. That's it. Oh God, don't you want to do one of those commercials, Ward? Those
Oh, that'd be
lawyer
so much
commercials?
Oh, I don't
Like,
know.
I'm Ward and I'm a badass. Oh man.
Oh, I'm not
funny.
sure. Some of them are good. There's
but
some that I
it's
think, oh, that's a pretty
funny.
good commercial.
And then you have
Most
to
of
have
them.
the eagle that goes by. It goes, ah.
Eh,
I know. Everyone, Ward is on the show every 4th Wednesday here on Big Blend Radio. Keep up with us at bigblendradio.com. Thank you so much, Ward. Always so much fun.
Thank you. It was fun.
It was cool.